So what we're going to do is change the order of the two speakers and have Nancy Chi Cantalupo go first. She earned her law degree from Georgetown and then a Master of Laws degree from Temple, and is now an Assistant Professor of Law at Barry University. Prior to that, she worked with a higher education professional association, specializing in equity, inclusion, and violence, and she was a research fellow with the Victim Rights Law Center. She's been an assistant dean at Georgetown Law and associate director of the International Legal Studies program at American University, and has also been in private law practice. And she's a real expert on gender-based violence in education, and really she comes very well recommended to us. She's worked with the White House Task Force to protect students from sexual assault, participated in a Senate roundtable, as well as testifying before various state legislatures. The Department of Education asked her to serve as a primary negotiator on the Rulemaking Committee that was charged with implementing the amendments to the Clery Act made by the Violence Against Women Act. And that's something Laura Dunn is also going to be talking about, so I think it's really very helpful to have both of them here to give their respective views. And a lot of people don't know that the Violence Against Women Act, reauthorization of 2013, did a lot to embed into statutory law some of the things in the Dear Colleague letter from the Department of Education in 2011 that were merely administrative rulemaking. I mean, not all of them, but some of them. So we're going to look forward to learning more about that. So Nancy, and you can maybe just put that in the pocket. Okay.
Sorry. Okay. Thank you, Professor Hubbard, for inviting me to speak, and for you all for coming at this early hour on a Saturday. So my comments today are drawn mainly from an essay that I recently published with the Yale Law Journal Forum. This is their online publication, and it has the same title as my talk today. So if you're interested in more information, or if you retain things better by reading them rather than listening to them, then feel free to look it up. So I am going to be doing some reaching to advance my slides. But so the essay is built around three recent sets of legislative proposals that seek to criminalize Title IX by conflating or importing concepts and procedures used by the criminal law into the Title IX context. And these three efforts are just listed on this slide: mandatory referral, criminalized procedures, and affirmative consent, all of which are not just a single legislative proposal, but actually a set of legislative proposals that have happened both at the state level and at the federal level. Well, affirmative consent has not happened at the federal level because affirmative consent is a matter of state criminal law, and so the federal government doesn't have any jurisdiction on that issue. So I'm just going to discuss these three topics sort of in order as they're listed on the slide. So I'm going to start with mandatory referral. And I always start, I'm sort of assuming that most of the people in this audience are already aware of these statistics, but just in case, I'm putting them on the slide, and at the very least to remind some of us that there is a very high non-reporting rate, and it mainly results from the poor reputation of how those in authority, including police, legal and medical authorities, and campus administrators, treat survivors. And because of the large numbers of victims and the large percentage of victims who don't report, there's been a concerted effort by folks at the national and local levels to expand reporting options. So Title IX's flexibility as a civil rights statute makes it possible to expand the reporting options to set up the two-path reporting system that I've summarized very briefly on this slide. So as you can see, under this system, survivors can disclose to a confidential person or office, or they can report to the Title IX coordinator directly or to a responsible employee who would then advance the report to the Title IX coordinator. And survivors can also switch from the confidential path to the non-confidential path at any point. So this structure is modeled after a similar two-path reporting system that was used with significant success, or that has been used with significant success in the U.S. military, where it's increased reports in a system that also had extremely low reporting rates. And of particular note is the fact that many military sexual violence survivors opt to switch from the confidential path to the non-confidential path. So the two-path reporting system has also increased the number of reported perpetrators who can be identified and potentially prosecuted. So recently, there has been a push to mandate that college and university officials refer all reports that they receive from students to local law enforcement. And in stark contrast to the steps that have been taken under Title IX to encourage reporting, mandatory referral eliminates reporting options. It does this by essentially turning all reports, including Title IX disclosures and reports, into an indirect report to law enforcement. And this kind of mandatory referral creates three groupings of problems. So first, mandatory referral actually engages in direct gender discrimination by stereotyping and infantilizing victims, the majority of whom are women. So nearly all mandatory reporting schemes are used to protect children and others who have significant legal dependencies, such as the elderly or persons with certain disabilities. So for the most part, mandatory reporting exists for these groups because of their greater vulnerability, which comes in part from these groups' legal dependence on others. However, college victims are adults without any legal dependencies, so mandatory reporting would treat them legally as children without any justification for doing so. And this is pretty much the definition of discrimination. And as you might imagine, any law that directly discriminates on the basis of gender in this way would violate Title IX. So second, there is a poor record and reputation of law enforcement when dealing with sexual violence victims. And that's not the focus of what I'm going to talk about today, but I'm happy to talk about that during our discussion following the presentation if you're interested. But I want to focus on the sort of the remainder of my comments today on the structural issues that are listed in the third group on this slide. So these structural issues exist regardless of how well the criminal justice system works. So in other words, even if police, prosecutors, courts all did their jobs 100% of the time, these structural issues would still remain. So there are just some things that the criminal justice system is not designed to do. And it turns out that many of the harms that sexual violence victims experience cannot be remedied by the criminal justice system. So because even a perfect criminal justice system cannot do everything, survivors need Title IX's civil rights equality-based approach in addition to whatever the criminal law can provide. The differences between the criminal law and Title IX civil rights approach mean that Title IX can assist victims in four incredibly important ways that the criminal law just is not set up to do. So first, Title IX's goals are about assisting victims and protecting their equality rights. As a civil rights law, Title IX is concerned with equal educational opportunity and equally supportive educational environments. The criminal justice system is focused on keeping the abstract community as a whole safe from violence, and basically relies on incarceration of criminal actors to achieve that safety. But of course, that incarceration needs to be just, and we cannot be depriving citizens of their liberty under the Constitution based on crimes they didn't commit. This means that the focus of the criminal system is on the defendant's rights, not on the victim's needs. In contrast, incarceration is not the focus of the equality-based Title IX approach because schools can't lock people up. And in addition, schools have concerns that are not represented in the criminal justice system, like ensuring a good living and learning environment for all of their students. So instead, the civil rights approach is fundamentally focused on the victim because the right to be free of sex discrimination is the victim's rights, not the accused perpetrators. And again, this is because, and I don't have a slide on this, but when I say sex discrimination, the reason why sexual assault is a form of sex discrimination is because sexual assault is a severe form of sexual harassment, and sexual harassment has been recognized actually throughout the world for 30 or more years as being a form of sex discrimination. Okay, so this slide just summarizes the downward spiral that victims can experience if their needs, particularly in the immediate aftermath of the assault, aren't met. So the accumulative effect of these problems can seriously derail and even ruin victims' lives. Sexual violence causes serious health problems. These health problems then often require time off and usually cause a drop in grades and educational performance. And both of these result in economic losses like financial aid and tuition dollars in the short term. You know, tuition dollars spent on classes that the victim couldn't complete. And in the worst cases, in the long term, a student ends up dropping out or transferring to a less desirable school. And the negative impact of this on future earning potential is likely to be incredibly large, although hard to really calculate with a lot of accuracy. But what it means is that this negative effect on students' equal educational opportunities then translates into unequal employment opportunities before the students are even starting in the workforce. And like with people who are already working, these dynamics have a greater impact on certain students, right? So first-generation college students or undocumented students, students who are vulnerable in multiple ways, are going to have greater difficulty if they are assaulted, because you need resources to create the time and space to heal from the violence and from the trauma, and that just is more difficult if you are from a more vulnerable position. Okay, so Title IX civil rights approach tries to stop the downward spiral by requiring schools to provide victims with a wide range of services. So resources, accommodations, medical services, counseling services, etc. All of these are designed to intervene and stop the effects of the violence. And the approach recognizes that in order to reestablish an equal education for the student, the school must do more than punish the perpetrator. In fact, the school must do these things regardless of whether the victim even identifies a perpetrator. And most importantly, the school must provide the victim with changes in living, working, transportation, and academic arrangements, things like stay-away orders, tuition refunds, and other remedies for victims whose trauma makes it impossible for them to continue with their education in the same way that they did before experiencing the violence. And the criminal law, even if it wanted to, is just not structured to provide this kind of assistance. It's not set up to make a victim whole in the way that civil rights law is designed to do. Okay, so the third difference brings us back to the expanded reporting option. So through the two-path system that I've already discussed, the Title IX civil rights approach allows the survivor to decide whether an investigation should be initiated. If survivors disclose to a confidential employee, they can access the services, resources, and accommodations that I've just been discussing without an investigation. But if they report to a responsible employee or the Title IX coordinator, their report will be investigated. And essentially, this means that survivors can control whether an investigation happens by choosing a particular reporting or disclosure path. Again, in contrast, under the criminal system, police and prosecutors decide which cases are investigated. And in fact, their primary function is to investigate, to determine what happened, to see if someone needs to be charged, tried, and convicted of a crime. And survivors, of course, know that this is the function of law enforcement, and we all know that this is the function of law enforcement. So if survivors just want help getting their lives back on track, after the trauma, if what they want to do is get their lives back on track, and they don't want an investigation or don't know if they want to investigate at that point, particularly in the immediate aftermath of the assault, they're going to want to go to the Title IX system because the Title IX system provides them with choices. And again, this is why mandatory referral is a very bad idea, because mandatory referral would force survivors to go to the criminal justice system, even if all they want are the remedies that Title IX and only Title IX can provide. And if survivors simply don't report because they don't want to be forced into an investigation, they also will not be able to access all of these Title IX-based services and accommodations. Okay, so fourth and finally, for the differences between the criminal system and the civil rights approach, Title IX requires something that I call procedural equality. Because procedural equality is a sort of fundamental idea in a civil rights system. So procedural equality means that both parties to a proceeding get equal rights within the rules that govern the proceeding. And this is very much not the case in the criminal system, mainly because survivors are not even parties to criminal proceedings, right? They're merely witnesses. The prosecutor is not the victim's lawyer. The prosecutor represents the state, whereas defendants do have their own lawyer. So you're already coming to it from a completely unequal position. And so another place where there's a stark contrast between the criminal and the civil rights systems is in terms of the standards of proof. So civil rights systems require the preponderance standard of proof, whereas the criminal system uses the beyond a reasonable doubt standard. And the reason why the preponderance standard is the most equal of all standards of proof is because it gives as equal as possible presumptions of truth-telling to both parties. Other standards give a heavy presumption in favor of the accused. And these standards can be taken, and many survivors do take them this way, as a societal belief that victims lie. Sexual violence cases are often credibility contests, so a process that builds a strong presumption in favor of the accused can be seen as a symbol that we believe victims across the board are so much more likely to lie than the perpetrator is, that we have to build safeguards against that lying into the very structure of our proceedings. So such an assumption is manifestly unequal because giving presumptions in favor of one side or the other is by definition treating them unequally. But in addition, in the context of sexual violence, a systemic assumption that victims lie is a kind of gender-based stereotyping that is widely recognized as being a violation of equality rights. Okay, so it's also important to remember that the preponderance standard is used in the vast majority of cases in our legal system. If we used a different evidence standard in campus sexual violence cases under Title IX, we would be saying that victims of sexual violence should be treated unequally compared to the vast majority of other people in our nation, including all other students in our colleges and universities. Okay, so for all of the reasons just stated, mandatory referral and criminalized procedures are manifestly damaging to Title IX's equality-based goals. Why affirmative consent, oh, sorry, I got off track a little bit, did I?
We're back to
Yes, here we go, sorry. So why affirmative consent is damaging to Title IX's civil rights approach is a lot more subtle. So the baseline difficulty with affirmative consent is that consent, regardless of whether it's affirmative or negative or any kind of consent, is a criminal concept, and it's judged by criminal standards. So using any form of consent to deal with Title IX matters is once again criminalizing Title IX. The subtlety comes in with the fact that affirmative consent does in fact bring us closer to Title IX's actual standard, which is welcomeness. So welcomeness is the standard that was developed in the employment discrimination context under sexual harassment law, because sexual harassment law was originally developed in the employment context. And it's always, because Title IX has followed in the steps of Title VII, it has always been required. Welcomeness has always been the standard under Title IX. But schools don't seem to have understood that because they overwhelmingly use consent rather than welcomeness in their policies related to sexual violence in particular. And oftentimes, you know, this is related to the fact that many school conduct policies, for instance, will separate out sexual violence from sexual harassment. Whereas the way that the Title IX doctrine has dealt with them is, as I said before, that sexual assault is just a severe form of sexual harassment. So the fact that schools have not used welcomeness in their policies and have often used criminal consent concepts instead. So when I was in college, the consent or sexual assault in our student code of conduct was defined, and this is in the 90s, was defined as carnal knowledge of a female. And that was taken directly from the FBI's definition, which was not amended or changed until 2002. If schools had been using sexual harassment as they should have been under Title IX, this would not have been a problem. But that's where we are. So the other reason why affirmative consent is actually problematic is because welcomeness is a better standard. It's more flexible. It takes into consideration the subjective and objective perspectives of both parties in the proceeding, and it uses a sort of totality of the circumstances kind of approach. That allows for you to take into consideration all kinds of factors that are a lot less easy to take into consideration in the relatively rigid criminal definitions that we have for most crimes. So what I've proposed in this essay is that you know, I don't have any problem with the affirmative consent movement. However, I don't think that it belongs in the Title IX context. Because one, we don't need it, and two, it actually could make how we deal with sexual violence on college campuses worse, rather than and less flexible. So what I propose is that if folks want to change consent definitions to affirmative consent, that the place to do that is in the criminal code, not within educational policies. And that within educational policies, it would be a very easy fix to just, for those institutions that have adopted affirmative consent, to simply replace the references to affirmative consent with welcomeness. So thank you very much, and that's it for me.
Thank you, Nancy.
I got your...
Go ahead and keep yours up. I mean, let's do some questions first.
Oh, okay. Do you want to do it that way rather than just do the questions at the
that's
end?
the way I prefer.
Okay.
So first have questions for you, and then... That's okay.
Yes.
Can I start?
Sure, absolutely.
So a side note and then a question about the argument you have about the burden of proof. So the side note is, I take it that actually your college would have said carnal knowledge of a woman against her will, because that goes all the way back to Blackstone. And it would be the against the will that's the part that's the consent. Carnal knowledge is just the sex part. But I don't understand why you think that a beyond a reasonable doubt means that we assume women are lying. So in UVA, every other rule requires proof beyond a reasonable doubt to be excluded under the honor code. So if you, in fact, have professors who are accusing people of cheating or of plagiarism, in order to throw a student out, you have to prove beyond a reasonable doubt that they were cheating. And I don't think that
Kimberly,
shows...
that's actually not true here at UT, because I've just been dealing with the case of this, of a student who has appealed this all the way through the system, even though I could prove mathematically that the chance that his answers were random were 1 in a billion. But I was nevertheless told it's preponderance of evidence.
Well, it may be different in different schools. The question isn't what it is at any individual school. The question is what inference we're supposed to draw from what the burden is.
Right.
So under Nancy's argument, the inference we're supposed to draw from a proof beyond a reasonable doubt standard would be that professors lie, and therefore we're skeptical of professors, and that's why we need proof beyond a reasonable doubt. I don't think it entails anything like that. I think the question is when you're going to, in fact, inflict stigma and, in fact, some sort of harsh treatment on people by throwing them out of school or suspending them from school, what standard do you want? And, of course, we should start with the fact that anyone in an educational school is entitled to the same presumption that they're another functioning member of our system. And then the question is, how confident do we have to be? But a question of preponderance versus proof beyond a reasonable doubt, I don't take as a question of who we take to be the truth tellers or the liars, but how significant do we think the deprivation will be, and what standard do we want? So I just don't see why it has anything to do with whether we believe or disbelieve victims or professors, that we would put the standard one place or another.
Well, so I think we differ on our interpretation of what is motivating the adoption of certain kinds of standard of proof. You certainly, the reasons that you state are certainly ones that are discussed in the literature, particularly related to the criminal law, right? The idea of unjustly incarcerating people and avoiding false negatives or avoiding false positives regardless of how many false negatives that creates, because we don't want to be, because our commitment is to not incarcerate people. So the question would be, and we discussed this a little bit at dinner last night, is, you know, what exactly are the consequences? You know, the assumption is that that there is an enormous amount of stigma attached to merely being accused of a sexual assault or plagiarism, right? And you know, I think that needs to be empirically dealt with. But for me, the way that these cases happen in real life is that they are credibility contests. And they're credibility contests in a way that plagiarism is not, okay? As you indicated, right, you can draw all kinds of evidence to show, you know, documented evidence to show that plagiarism has occurred or hasn't. In addition, plagiarism is a much more state versus, it's much more similar to state versus student or state versus defendant in the criminal context, right? Because the school is essentially prosecuting the case. The school is the one who has much more information and has much more power and coercive ability in that context than in the context where you have essentially the school trying to determine what happened between two people with no witnesses and very little evidence. So that's where the credibility contest comes in, and the way that we deal with disputes that are largely word-on-word disputes are in the legal system is through the civil context, and the civil context uses preponderance of the evidence.
I wonder if I could follow up here, because I had a question very similar to Kimberly's about the preponderance standard. And although you may be right that both accuser and accused should be accorded equal credence at the beginning of the process, we have to be aware that the consequences for the two are very different. If the accused is found guilty, the typical punishment that institutions apply is suspension or expulsion. And particularly in the case of expulsion, this is something that goes on a student's permanent record if they have been expelled for disciplinary reasons, making it all but impossible for them to be admitted at any other institution of higher education that is at all competitive or selective. The consequences of being wrongly found guilty can be life-changing for people and very deadly serious. Whereas on the other hand, what are the consequences for a sexual assault victim who winds up not being vindicated because there's a higher standard like clear and convincing evidence? The worst that she is going to face is that she might run into her assailant on campus, might have to be in the same classroom with her if they're studying the same subject. And although that may be regrettable, and I think everything should be done to, even in cases where there may not be complete proof, everything should be done to try and separate perpetrator and victim. we have to be aware that the sanctions universities are often imposing on people whom they do find guilty are dead serious.
Okay, so I'll respond to that with a couple of different ways, in a couple of different ways. So first, there is actually little evidence supporting several of the points that you made about what happens to accused students. So first of all, these proceedings are the school is authorized to keep these proceedings totally confidential. So the stigma that comes from these proceedings is not necessarily going to happen, right? Because it's not a criminal proceeding, it is not a matter of public record. Second,
are they required to keep the proceedings confidential?
Yes.
So if they have expelled a student for disciplinary reasons, they're required to keep that confidential?
Well, they're not required, but they do actually, right? So the other thing that we know is that the studies that have been done have shown that expulsion and suspension are actually rare, particularly expulsion, and that when students are expelled, it's not at all certain that that is put on their permanent record. There are, in fact, many students who have been expelled for sexual violence, who have been found responsible for sexual violence, and that has not gone on their permanent record because the school has a policy of not putting disciplinary results on the student's transcript. And so therefore, the school that is admitting, the school that the student then attempts to transfer to would have to reach out and ask the other school, the previous school, what happened. And many do not.
Their transcripts are put on hold when they're on suspension. They can't transfer because their transcripts are on hold. They have to start over somewhere else.
That's at some schools. It is not across the board, and there is no requirement in law for that to happen. And and in fact, we have many instances of students who have been found responsible for sexual violence, sometimes more than once, or have been under investigation more than once, who have moved to another institution and have managed to get a college degree. These are just facts. And so you know, there's I think that the issue of stigma is important and is a part of the policy conversation, but I don't think that it trumps the need to use an equal procedure in these proceedings, in keeping with an equality law and a law that is supposed to protect equal rights for all of our students. And I would also just suggest that what we know from the studies is also counters what you said about victims, which is that victims actually experience a huge amount of re-traumatization, which they experience over and over again every time they have to encounter their assailant. And that's made even worse if they have gone through a proceeding, they've actually initiated an investigation, and the accused student has been found not responsible. And then they can't, you know, they are made out to be a liar among all of their friends. That's assuming that the school has not managed to keep everything confidential, which would be the ideal situation, right? And that's part of the reason why schools do attempt to keep these things confidential. But the point is that victims actually experience serious traumas, and these statistics are gathered over decades of research with victims that show that this kind of trauma happens, and it has a serious effect on victims' futures. And so I don't think that we can just dismiss that as if it is, insignificant.
Oh, I certainly don't mean to dismiss or trivialize it. I mean, I've known survivors and known, the kind of emotional upset they go through if they do encounter their assailant again, even quite randomly. So I by no means want to minimize that. But I'm wondering if we can find some common ground here. Perhaps a preponderance of evidence standard would be enough for a school to make the decision to separate two students, make sure they don't have classes together, that they're not living in the same dormitory, to reduce the chances of their coming into any kind of significant contact with each other. Preponderance of evidence might be good enough for that. But I'm thinking if schools are going to be taking these really serious punitive sanctions, which they have in many cases, including cases even of what was actually consensual activity, then a higher standard in that kind of case, where the harm to the accused is going to be so great, I don't think there's a 51% possibility that this was true should be enough. I mean, shouldn't we at least have clear and convincing evidence if we're really going to do something that damaging to someone's career? And although you have made the point that schools are not required by law to put this on someone's transcript as a disciplinary expulsion, many do.
So all I can say is that I think practically that would be impossible because the school has to have. It's not until the facts are on the table and the investigation has happened that you would be able to figure out whether or not what sanction is appropriate, right? And and when you're doing the fact finding, you have to have a standard of evidence to guide that fact finding. So I don't think practically you could do that. I also, frankly think that's, I just disagree. I don't think that deals with the problem which I've raised, which is that these are credibility contests, and equality requires us to use an equal standard of proof. And preponderance of the evidence is the equal standard of proof. And the fact that it is used over and over again in civil rights cases and in the vast majority of cases where also very serious things happen, right? So people's children are taken away based on the preponderance of the evidence. Parental, those kinds of proceedings, there are very important things and very important rights that are taken away from people based on preponderance of the evidence. And so, if we're going to be talking about this in terms of sexual violence, I think we need to ask the question, why aren't we talking about using beyond a reasonable doubt in parental termination cases? Why are we just talking about it in terms of just sexual violence? And I think that raises that makes it clear that we think of sexual violence in a different way, and in a way that is the exception for sexual violence that is made in the law over and over again is very much based in inequality and sex discrimination. Yes?
The cabinet preponderance seems to be, to me, about the Department of Education requiring it in this one context and not the other. But to go on to the point you were just making about taking away people's children and these other contexts where we use preponderance, can you name any of those contexts, any of them, where you don't have a trained judge, where you don't have discovery, where you don't have rules of evidence that apply, where you don't have subpoena power, where you don't have lawyers that are allowed to represent people on both sides? Because in this context, you have lawyers who are allowed to sit next to you, but you have no actual right to have actual representation. I mean, all of these analogies to preponderance are contexts of robust procedural protections. And I'm unaware of any, if you can name one.
Yeah, I can name several, actually. You know, people's licenses, their medical licenses are taken away through administrative proceedings.
They have discovered. They have discovered. They have subpoena power in the proceedings.
Right, but they don't have to. They're not required by law to have those. The licensing board may create those kinds of rules, but they're not required by law to have them. And you know, and employment. I mean, people are fired, and there may be, you know, they and many of their family members may depend on their income. They can be fired for being arrested, not for having a conviction, not for anything else. People are fired for all kinds of reasons, and under circumstances where there is almost no procedural protection for those folks. So I mean,
right, but when you sue for discrimination for any of these reasons, and any of the courts that you're describing and analogizing to, when you sue, when you're in a court, or when you're in an administrative law proceeding, all of those things require these procedural protections.
But schools are not courts of law. These are internal administrative proceedings, and in fact they are they have a lot more. They look a lot more like a court than a lot of administrative proceedings that are used by employers, by licensing boards, and by those kinds of entities. So you know, yes, if you're in a court of law, that's different. But we're not talking about courts of law. Schools are not courts of law. Yes.
I'm really interested in if you could say more about this idea of welcomeness, and do you know in particular whether universities, colleges and universities, do you know that who have moved to that as a standard as opposed to consent, and whether the kinds of discussions and the kinds of adjudication within the university are actually working out better? Because it seems to me that, at least prima facie with welcomeness, that you would have a little bit less polarization between the two parties, that where there could actually become something more of a discussion about how welcome was that, and move towards something like a common ground. But that's just my guessing, because it sounds appealing. And do you know whether is it working out better in universities?
Yeah, so I don't know. I haven't done that research. There's so many universities that I haven't combed through all of the policies. But, you know, of course, welcomeness is used in the employment context. And it has, you know, it's been much more flexible as its use in the employment context seems to be, to have been much more flexible and subtle, like I'm suggesting it would be in the school context.
Okay, I think we'll really have to move on. But let's thank Nancy and at lunch.
Yes.
Our next speaker, and she is finally here after a harrowing night in Dallas. is Laura Dunn, who is a nationally recognized victim rights attorney. She received her bachelor's degree from the University of Wisconsin and her law degree from the University of Maryland. And she was very intimately involved in negotiating and advising on the 2013 Violence Against Women Act reauthorization. And that's an area where she really has a lot of expertise and has much to teach us. I mean, people are not nearly as aware of the impact of this law on what universities are required to do as they are the Dear Colleague letter and the Title IX rulemaking that is connected with that. She is currently an adjunct professor at the University of Maryland Law School and also the founder and executive director of Serve Justice, a rape survivors advocacy organization. And Laura's going to be speaking to us, and you see the title up there on the PowerPoint, Campus Sexual Assault as an Institutional Balancing Act, Procedural Requirements under VAWA. Welcome, Laura.
Thank you all for having me here. I so apologize for entering really loudly. I was stuck in Dallas all night, haven't slept a lot, so this will be an interesting experience. I don't normally come straight off a plane and run into a room and present. So bear with me, and if anything is unclear, you are actually welcome to ask me in the moment, and I want to be as clear as possible. So in addition to the background that was already kind of outlined, I do want to be upfront that I am very public about being a survivor of campus sexual violence and a survivor who did not receive justice. So when having conversations about what that feels like and how that impacts someone's life, I can tell you it is not pleasant, it is not easy. And at the same time, I am a lawyer. I do care very much about a process that is fair for both parties, for being thoughtful about the ways that we define and approach these issues, because even in injustice takes many forms. It's not just the denial of justice for someone who's been hard, but it is wrongfully finding someone responsible. So that's the context I want to come at this at. And I will say that through Serve Justice, we're a legal organization. So we actually go into campus hearings and work with survivors. And the reason we do that is actually related to this law. So I'll give you a little background on the law, and we'll kind of move from there. So I'll talk a little bit about VAWA, and I just want to be really clear. The Clery Act was amended by VAWA, the Violence Against Women Act, and I'm also going to mention the Campus Save Act, which was the initial bill. So I'll outline the history a little bit, but I'll be interweaving VAWA, Clery, Campus Save Act. They're all the same thing as far as the purpose of this conversation. In addition to giving you that overview, I'm going to talk a little bit about the negotiated rulemaking. I was the primary student negotiator, so students that are in the audience, you can actually go all the way to Washington and make federal law while you're a student. So keep an eye out for educational enactments because they want primary student negotiators. And I'll talk a little bit about the challenges there, because we're not just talking about rights for survivors and due process for the accused. We actually also have a layer of institutional liability. There's kind of three different main ways that we're approaching these issues. And last but not least, talking a little bit about what's come out of this, the best practice. And Title IX very much overlaps with FERPA, the privacy law we've talked about, and Clery. So all these laws are kind of converging. And then we have also due process and also state legislation. And so it's getting more layered over time, and we'll touch just a little bit about that. So the Clery Act, I always mention a little bit of history because I think it helps understand the purpose of a law if you know where it came from. So that's a picture of Connie Clery and her husband Howard, who is no longer with us. And they're passing the Clery Act into law with President Bush. And it's in honor of their daughter. So what actually happened to Jeanne Clery was she was just asleep in her dorm room in 1986. And a fellow student was out robbing dorm rooms and pushed open her door, and she happened to be in bed, and for reasons I'm sure no one will ever understand, he tortured her, raped her, and murdered her, and left her body for her roommate to find the next day. Just shocking violence, and of course needless. And the reason it happened, not just because that individual had this intention that night, it's actually because people left doors open. They left had me gone through to access Jeanne. So when we talk about campus sexual violence, there are very extreme cases. And I think sometimes we forget that in the current debate that's happening. But there's a reason we have these laws, that we really were ignoring very violent crimes happening on campus. So this law was passed in 1990, and it was definitely amended a few times. But just to give you a quick sense of what it looked like before VAWA, it was really focused on crime reporting, because the Clery family had this idea that if they had just known that violent crimes were happening, they would have never sent their daughter there. And in fact, they had chosen Lehigh University, where this crime happened, over Tulane. Because in their mind, Tulane, New Orleans, I guess there had been a violent attack recently. We don't want to send our daughter there. Let's pick Lehigh, that's in Pennsylvania and looks, very quaint and safe. And actually, when their daughter died, they did pursue a lawsuit and found there had been a lot of crimes. And in fact, this person that murdered her had been committing burglaries. And maybe if she had known burglaries were happening, maybe she would have locked her door that night. She had actually left it unlocked to let her roommate in, who forgot her key. Very innocent. And so the main thrust of it is parents should know how safe a campus is. And so one of the big features of Clery, which is different than Title IX, is it's geographically bound. They're thinking about what's happening on campus, how safe is the campus, not the city, not nearby, but the physical campus itself, to make schools accountable for their property and make sure that it's really secure. And so the reporting happens in two different ways. An annual security report, every single school sends this out. It comes out by October 1st. You can Google it right now for UT Austin, and I'm sure you can find the annual security report. And it has all the campus safety policies, how dorm rooms are locked, how you access campus, just very basic information. And it also has 3 years worth of crime statistics. And it covers major felonies, so murder is on there, theft, burglary, sex offenses are part of that. So the major crimes we actually report on for the UCR with the FBI. And there's also some more minor crimes that were included, simple assault, theft, larceny, and intimidation. And hate crimes. That was one of the amendments that came through. If there's violence on campuses targeted to one group, also information people should know in deciding whether that's the right campus for them. Timely warnings are part of that, and I'm sure the students here, you've probably seen a timely warning. So when there's some crime on campus, all of a sudden you get this email or this text message, and it says, careful for this block, suspect seen, assault happened. And the idea is that you would not go that way. You would not make that same decision because you know that there's an ongoing crime or an ongoing risk. So very, again, intentional to prevent violence, create awareness. And daily crime logs, so not just an annual security report. You could walk into your campus security office here on campus and say, let me see all the crimes that have happened in this dorm in the last week, and you could get a list. So if you're proactive and want to find information about what's happening. Definitions of property are also included. And very minorly, pre-VAWA, there was information about sexual assault programs. So the Clerys weren't just interested in letting people know crime was happening. They, of course, didn't want crime to happen at all. And so in 1992, there's a Campus Sexual Assault Victims Bill of Rights that does a lot about prevention and education, trying to create awareness about rape, acquaintance rape, and how to prevent these crimes and avoid them, mostly through risk reduction. And a little bit of procedures, making sure survivors had information about where to go, how to preserve evidence, really practical stuff. So that was pre-VAWA. That's what Clery was when it initially passed. And then VAWA actually created a very strong amendment. So the Campus Save Act, again, is another term for that. It's the initial name of the bill that was presented, and it stands for Sexual Violence Elimination Act. And a lot of people think it was post the Dear Colleague letter. It's actually pre the Dear Colleague letter. And it was inspired in part by an investigative series by the Center for Public Integrity that looked at campus sexual assault across the country for the first time ever. They looked at 33 cases and found that only 2 of them had any kind of finding of responsibility and very minimum sanctions, such as summer suspension, even if the student wasn't enrolled in any summer classes. So the Clery Center for, I should back up for half a second, the Clerys founded a national organization that's now called the Clery Center for Security on Campus. And so they were the main kind of push behind these issues. And so in 2010, when they saw that investigative series, they said, let's do a little more. Let's amend Clery yet again. And they started developing a blueprint on that. So long story short, it was introduced in Congress, Sexual Violence Elimination Act. You can see it took a little while to take hold. In 2012, it made it into the Violence Against Women Act, which originally passed in 1994. And for the first time ever, it didn't pass. Congress used to pass it almost unanimously every single year, and it didn't pass in 2012. So in 2013, you can see that's a little picture of me at a press conference with Nancy Pelosi and the rest of the Democratic leadership. There was a big push, and it did in fact get passed, was signed into law, and as of March 2014, it was actually enforced on campus. And the standard was a good faith compliance. The U.S. Department of Education, I think, was very generous in allowing schools time to get up to speed. And right after that, the Bachelor Rulemaking Committee happened, and Nancy was one of the negotiators on that, along with myself. So we'll get into that a little bit later. But as of this school year, the entire legislation and all its regulations were enforced for the very first time. So we're just starting to see the impact of this law. And unlike Title IX, we're not talking about guidance, we're actually talking about statutes and regulations enforceable. So what did VAWA do? Well, this is actually the most important part. So looking at the campus security policies, it just expanded crime reporting and said, let's not just focus on sex offenses. Let's actually talk about dating violence, domestic violence, and stalking. And it actually also changed the definition of sex offenses because actually the FBI had changed its definition. So it became more modern and moved away from carnal knowledge that was mentioned before to a different standard we'll touch on. And so sexual assault is the other term. Sexual assault, dating violence, domestic violence, stalking was added. So you can actually see those reported on your campuses now. Timely warnings had a little more privacy added to them, but the real meat that I'm going to focus on when we really get into it is around the sexual assault programs and procedures. So for the first time ever, because Title IX really didn't do this all that meaningfully, it required schools to have prevention education for all incoming and students and employees. And it was very explicit, and it was focusing not just on telling risk reduction, women don't walk at night, carry reversal, make sure you know where blue light is, but actually thinking about bystander intervention. How can we make sure our friends are safe? How can we intervene before there's a problem? And thinking about risk reduction in a more meaningful way, how do you know if you're in an abusive relationship? How do you know if maybe you're too drunk and you might want to avoid the scenario? So thinking about kind of more meaningful prevention education if we're talking about the issue of acquaintance rape as opposed to stranger assault. And of course, trying to reduce perpetration, having conversations about consent, what that means, what that looks like, how you should obtain it, and how you might actually be committing sexual violence rather than seeking someone's consent. And in addition with that, we actually got a lot of procedural protections, not just for survivors, but accused students as well. So a lot of the things that are guidance in Title IX and somewhat vague and left up to others, right? Prompt, actable, what does that really mean? We have a lot of guidance trying to figure that out. This was very explicit and set certain benchmarks that are just set in statute. Written notification to both parties, right to an advisor choice for both parties. So very explicit access to information before hearings. We talked about discovery. There is a requirement in statute now. Actually, that's been explicitly regulation more so than statute. So it created a lot more concrete standards that I think really help schools kind of move away from meandering into guidance to thinking about something concrete. And the last 2 points, retaliation protections were added, and actually there's a requirement that the government give more assistance to schools. If we're putting all these burdens on the schools, should we also tell them what the best practices are? How do you even do this right? Because a lot of people have accused Title IX and this of being unfunded mandates. And in many ways, they have pushed schools, and there is a great extent to that unfortunately gets passed along to students. So, kind of just briefly touching on things so that we have an understanding. I'll move pretty quickly through this, but I mentioned stalking was added, and the definition was adapted from VAWA. So if you read your school's policies, you should actually know the definition of stalking in Texas that a criminal court would use, but you should actually know what the school has to use according to federal law, because we are talking about misconduct hearings at the campus level, not just crimes. And so at the campus level, stalking is a course of conduct directed at someone that either cause them to fear for their safety, the safety of others, or potentially suffer substantial emotional distress. And I won't dig too deep into it because it's not the focus, but the course of conduct is very expansive. It includes cyber harassment, bullying, stalking, so a little more progressive and thinking about a reasonable person standard, considering someone's identity and their situation. So a little more progressive than traditional law. There's also dating and domestic violence, and domestic violence is largely defined by criminal law. It just adapts and pulls from it. So sharing a house with someone in a romantic kind of context, whether it be spouse, having a child in common. But dating violence is somewhat new, and actually a lot of discussion was had at the Rulemaking Committee about dating violence. So it's any kind of ongoing intimate or romantic relationship, aka hookups, could be included as part of dating violence. And there was a huge discussion of how do you know they're together, because they're not going steady, and I don't call him my boyfriend. There is an analysis of taking the reporting party's word, but also thinking about the length and the type of the relationship. But these are all for crime reporting purposes. So if someone comes in and says, I haven't seen this guy for a while, and he hit me, and he assaulted me, it would be tallied as dating violence for statistical purposes. And of course, sexual assault. So Title IX, obviously, we're talking about sex discrimination, sexual harassment, sexual violence, and kind of a broad span. Sexual assault is pretty concrete. There's 4 different types, and the first 2 that I've defined are the ones you're going to find most often on campus. So rape, whether that be oral penetration or other penetration of the body, all without consent, and fondling, touching for sexual gratification without someone's consent. Federal law doesn't define what consent is, and it does that intentionally because that's left to states. States have traditional police power, and they're the ones that have to define that. The federal government at least says it's without consent, so just leaving an open-ended question for every campus to find an answer for. And kind of moving past the definitions, because that was the expansion for reporting, I mentioned there was a lot done on prevention education, and actually consent comes back up here. So mandatory training for all incoming students as well as the employees, and thinking about primary prevention. So rather than saying avoid rape by not going out, not being near people, not being in unsafe areas, thinking about how can we actually make our campus safer so that people don't have to worry about being raped. So looking at community-wide or audience-specific training as part of that, and really focusing on promoting safety, reducing perpetration. And what a lot of schools have done to focus on reducing perpetration that is actually required is to provide a definition of consent for sexual activity. That's a mandatory requirement under this federal law. And that's where a lot of schools have decided to go with affirmative consent as an opportunity. And I think for prevention education purposes, it makes a lot of sense because we are talking about if you're really interested in having sex with someone, what are you supposed to do? Get their consent. And what does that look like? It's unambiguous, it's voluntary, it's clear, and it's ongoing, and it's related to what activity you're seeking. So I think a lot of schools have really grabbed affirmative consent in relation to this mandatory requirement to have consent in their prevention education. And it's not just that, there's bystander intervention there, safe and positive options to intervene to make sure that people can assist you. And again, pushing the thought of risk reduction, so not just the stranger assaults, but abusive relationships. What does that look like? How do you identify it? And ideally also what your rights are. So how do you get a protective order? How do you get out of that situation with assistance? And federal law said, don't just do it once. Don't just mark a little box and say, well, we did it for the school year, everyone's going to be safe. Have some ongoing prevention education programs and really make it a focus. So I think the biggest impact that VAWA has had is truly on prevention efforts. But the other significant piece is response. And I'm a big believer that response and prevention are full circle. You can have every amazing prevention program in the world, but if your campus is horrible at adjudicating sexual violence, how is that sending anyone a clear message? It's wrong, but you won't get any justice. Or we set this very clear standard, but we're not going to use it in our hearing when it comes to you, right? We need to have kind of uniform policies. So there's kind of 2 thoughts with the procedure. The first is just focusing on survivors. Survivors have rights regardless of whether they formally report. So just disclosing to an individual that's a campus official, you automatically have this information provided in writing to make sure that it's very clear what your options are. And that includes all the possible sanctions if you did want to move forward using the campus process, as well as how you could be protected, what that range looks like. And I believe Tom had mentioned separating students, right? That's a real reality that schools have to deal with. And not just that, preserving evidence, because survivors do have the option to use the criminal justice system at any point. And that option actually under federal law is not a requirement, so they also have the option not to. And I think that's part of a long recognition that the criminal justice system hasn't actually done that great a job of addressing violence against women. How can I reinforce that statement? The Violence Against Women Act in 1994 that had significant congressional hearings that found pretty consistently that states ignored domestic violence, ignored sexual assault, and really allowed women to be abused by third parties without intervening. So making sure that survivors have that option but aren't forced into that option. And information about confidentiality, what that looks like, that's a right for both parties under FERPA, but being explicit so that the parties know. And on and off campus resources, and you'll see that listed on there, victim advocacy and legal assistance have been added. So kind of a nod towards these disciplinary hearings, not so much just being between student behind closed doors, but we are having advisors come in. We're having lawyers sitting in there, and it is getting a lot more intense. And of course, last but not least, and very related to Title IX, reasonable accommodations. We want to make sure anyone who's victimized by crime can still stay here. So if you were, apartment was broken into and it was an attempted assault, we want you not to flee this campus and say, I will never be safe again. We want you to live someplace that's more safe. We want you to have escorts as long as you need that. We want to make sure that that exam you're supposed to take the next day gets moved so that you can stay and be part of this campus and access your education. But probably the part that's most interesting to everyone is the rights that go to both parties. And I really do think this is significant. Title IX has a lot of benefits, but I think it's not the only thing. I think having clear standards set by federal statute is very important. So a fair, prompt, and impartial hearing is the right for everyone. And this is actually really important. We're talking about the accused at a private school, because they don't have due process rights. They still have the right under federal law to fair, prompt, and impartial hearings, because this attaches to federal funding, regardless if you're public or private. Officials being trained. It was brought up before, we don't have trained judges that are hearing these cases. It is absurd to have people who know nothing about a topic decide and choose people's fates. We do want training. We want people who can identify issues of violence, know what that really looks like, not just the stereotype they have in their head, but also are trying to make a decision about accountability and safety. What's going to be best for this campus to keep everyone safe and make sure if something has been done wrong that there's accountability for that. There's the same right to have witnesses present, so there's no favoritism. Similar to Title IX equity, the same right to an advisor of choice. And I can say that I fought hard as a student negotiator to allow this to be a lawyer. And the biggest objection I heard was, well, the accused will have a lawyer, but no one's going to help the survivors. Well, that's why I founded Serve Justice. I think both parties should have advice. I think both parties should know their rights and have a fair opportunity to enter a hearing with the ability to advocate for their side. So that is now in federal law, and the right to have a written decision. And this is really important for both parties. That decision has to have a reason. It can't be arbitrary. It has to have a justification for why you decided by hundreds of the evidence, which is not set by the standard, but is set by Title IX and deferred to under this. Why did you find that person responsible? And if there is a sanction, why was that the right sanction? How did that effectively address, based on community norms, this violation of misconduct? If there is a right to appeal, both parties have it. I will say neither Title IX nor VAWA give a right to an appeal, which has been debated, but neither do. And of course, if there's any change to the results, survivors and accused would know that. So if someone changed it arbitrarily, you should have a notice and you should be able then to intervene and advocate. So that was all the VAWA statute, and then we had to do the regulations. And sitting at the table, there were kind of three main kind of interests that were being represented. And I actually, now that I think about it just a little more, I could have added the government's interest as well. But really, it's survivor rights, a lot of attorneys and advocates and organizations there. Institutions, not just for liability, but also thinking about academic freedom, making sure that these are misconduct and honor code violations, not being kind of taken over by the federal government and made something they're not. And rights for the accused, and to make sure that their rights, not just under VAWA, but FERPA and Title IX, all those rights are preserved for all parties. So going into that rulemaking, there were definitely some areas of debate, and I won't belabor too many of them. But around crime statistics, there was a huge question. Schools didn't want to have to report if there was one egregious incident that had a lot of violence, every single type of violence that occurred. And so the hierarchical rule says the worst of the crimes, so sexual assault and if there was a murder and an arson, making sure that you stagger that out so it doesn't look like 100 crimes happen when there's maybe one really egregious scenario. And that relates to institutional liability, right? They can be sued under tort statutes for having an unsafe campus. So they want a realistic picture of how safe or not safe it is. And we kind of compromise and said, for gender violence, you don't have to put a tally, you don't have to put a number, you can actually put a description. So if it was one really egregious scenario, you can write that out so we all know it was one kind of uniform situation. The definition of consent was actually a huge point of contention. So there's 3 different meanings for VAWA. You can look at ed.gov and look at VAWA rulemaking if you're really curious about this aspect. But the second meaning for the rulemaking committee, there was actually a proposal from the federal government to define consent. And it really was looking at affirmative, involuntary, ambiguous, and related to specific acts. And there was a question, do we adopt that, do we not? And they actually did it. There is no definition of consent still, but it was largely debated, and a lot of survivor and survivor advocates groups pushed for this because I think if you're just thinking about it, why should consent be different if I enrolled at Johns Hopkins versus the University of Maryland? Why should I be protected differently and the scenario looked at differently? But the reality is, again, the federal government has left this to the states. This is really left up to the jurisdiction. And that's why you see California and New York kind of doing uniform campus-level definitions to try to get that same protection. So it's not, if you went to an elite school that had a great team that made a good policy, you're protected. But if you went to the community college that didn't realize they could even have to comply with federal law, sorry, you're not protected. So that's a lot of where the uniform consent policies have come from, but it wasn't adopted. And instead, the White House Task Force to protect students against sexual assault used a lot of that definition to kind of put out sample policies and recommendations for schools instead. With primary prevention, a lot of schools were debating whether they should be required to have research-based prevention programs, and the sad reality is we don't have great research-based programs. We don't actually know how to prevent gender violence. How sad is that as a country that we're having such a big debate about campus sexual violence, and yet we actually don't know the best way to stop it. So the good news is VAWA is requiring campuses to do this, and campuses are allowed to actually assess the value of their own prevention education programs. So hopefully, over time, we can have amazing institutions find better ways to kind of deal with this issue. And last but not least, there is definitely significant discussion around procedural rights. I mentioned with the advisor of choice that I fought really hard for it to be a lawyer. Schools did not want anyone outside of their campus coming in to advise. It was very, very hard debate, and I think it's a hard fought right, not just for survivors, but the accused, to be able to have someone in their corner that will advocate for them, and it does not work for the school who ultimately is going to make the decision. So to me, that's the best part of VAWA. That's a real door opener. It may not be everything, it's not the right to counsel, but it's at least better than what was before. And timely notices, there is a right to promptness, not just under Title IX, but under VAWA for both parties. And traditionally, if you're in the criminal system and an accused has a right to promptness under the Constitution, but they can defer it, and they can actually make the criminal process go a little longer by deferring that right. That's not an option under VAWA. The promptness right is for both parties, and so there's a lot of debate. What if an advisor isn't available, or what if one student wants to keep delaying it? Because it's on both sides, what we decided, looking at institutional responsibility, the rights of the accused and the rights of survivors, is that there should be good cause reason put in writing if there is going to be a delay. So still forcing schools to be transparent about what they're doing, because there could be a variety of reasons for their attempts to delay. And of course, the written results, highly debated again. Schools did not want to have to put a reason down. And our argument that ultimately won was, well, what if they pick something arbitrary? What if they actually violate a student's rights? Or, what if they decided because he was a male student, he was responsible, because of course men rape? Or what if it was a male victim and men can't be raped? We don't think that that's possible. Put that in writing and let a lawyer go to town, right? That would not happen. So it was really forcing schools to be honest and transparent, and ideally create a lot of avenues for justice for both parties if they feel like they were wronged in the process. So a lot of debate there. And so just to kind of wrap it up, the best practices that have kind of come out of this new legislation, in my opinion, is single policies. So schools had Title IX policies, and then there's Clery policies. sometimes had different policies depending on how many schools and graduate schools and programs, like if you went to Harvard, every single one had their own. So I think a lot of schools have said, okay, there's enough overlap with Title IX and with VAWA, and FRBO relates to all of them. How about we just have one policy that's clear for everyone and available in one spot? And some states, as I've already mentioned, just decided, well, let's not even let every single school figure this out. Let's just blanket it. So New York did that, blanket policies for prevention education, blanket policies for procedure, blanket definitions of consent, just making it very clear and easy. There's debate about whether that's wise, but a lot of states have moved that way. And a lot of schools have added amnesty policies along with confidential reporting to encourage survivors to come forward. And another area of debate I should mention from the VAWA rulemaking that now is a best practice is schools are required to list every possible sanction. So when Nancy was up, there was a great question about what about suspensions and expulsions. Schools can pick any list of sanctions they want. They literally can have writing an essay in their policy as a finding potentially of stalking or dating violence. Schools are not limited in what sanctions they have to choose. Some schools have chosen voluntarily. So SUNY has said if you commit gender violence on our campus, expulsion is the default. Suspension is an option. Nothing else is available to you. And so some schools are taking that hard line, but really schools can list any sanction that they want and have it available. And a lot of schools didn't want to list their sanctions. They want to keep it vague and open-ended. And I think it's fair for both parties to know what is on the table when you're walking into a hearing and what you're really fighting for. And along with that, the prevention education, affirmative consent has come out of that, as I mentioned, as debatably a best practice. I think for prevention, it really does, again, equip people who are interested in sex and how that conversation should go and what it should look like. And bystander intervention, making sure that people don't just know warning signs, but actually know what to tell a survivor, how to get help, where to go, how you can report, and really assisting them through that. So focusing more on the procedure aspect, because I have a feeling that's probably the one of more interest to everyone in the crowd. So one of the best practices that came out of investigations is notice. That has come up as a pretty consistent violation of accused students' rights. Not having noticed that someone has reported them for gender violence. And so because there is a strong requirement under VAWA to give information about no contact order, protective orders, and immediate kind of steps along with Title IX and their demand for interim measures, there has been a move towards the best practice of pretty prompt notice, because you have to tell a student why there's a no contact order against them. They have to actually know someone's reported them, and that allows them to start working on their defense in response to that. Another kind of debate has come up about no contact orders. Should that go against both parties or one? At Serve Justice, we feel it should go against one, and the survivor should be asked to comply with it, so that's not retaliation. So that is a best practice, just a no contact order against those accused. It, of course, it has to be temporary to honor due process. It has to have a pretty prompt hearing to justify that action. But schools do have that authority to immediately intervene. I think a lot of schools have moved towards writing out investigative reports and summaries because, again, at the end, they have to give a reason for their finding. So it's not just vague and we're moving to a hearing and there's no discovery, we can't show you anything, but have fun when you show up and try to defend yourself or present your side of the story. Instead, they're moving towards a written packet, and a lot of them are giving hearing packets to the advisor and to the party that, whether they be the victim or the accused, beforehand and through a cloud, because there are FRBO protections. That information should not be public, should not be handed out. And some of these, I would say, I put it on there as a best practice because the Department of Education came out very clearly. There has been debate about whether pattern evidence should be included for fairness to the accused, but the Department of Education, and I believe the Department of Justice, because it came out of University of New Mexico decision, said pattern evidence is part of it. Because under Title IX, we're not just talking about an individual incident like we are with VAWA, we're talking about a hostile environment that's created for others and that pattern of ongoing discrimination. I think a lot of schools have moved to pre-hearing meetings, and I will take a caveat. Some schools have single investigator models. I hate them. I think they're dumb. I do not agree with them. Why on earth would you have one person do everything and not have a formal opportunity? That being said, in a minute when I talk about hearings, I don't believe in adversarial hearings. I don't think we're in a court. I think we're in a school, and I think it should be inquisitorial. But a lot of schools that have the hearings, which I think is best practice, have pre-hearing meetings and set the groundwork because there aren't rules of evidence in these hearings. And that is a huge problem for both parties. And so there should be norms and standards, and schools have every ability to set rules of evidence, say no character evidence. Some of them exclude experts, some of them allow experts. There is a big ability for schools, and the best ones are making sure that witnesses have first-hand information, no hearsay, relevant information, so not just personal attacks against someone, no character witnesses. And I think that's a good step, and I think schools should keep moving in that direction. And I think schools are giving packets to adjudicators beforehand, allowing them as well as the parties to actually really analyze the information, have it available, and starting to prohibit last-minute surprise evidence. We do want a better procedure. We do want fairness. We don't want this to become the kangaroo court that it is often akin to. And I already kind of touched on the last part. So hearings, I mentioned that I don't think they should be adversarial. I actually think they should be inquisitorial. So the best schools that I've seen do it actually decide. They have a full packet, they have all the information, they decide which witnesses they want to hear more from. And I think that avoids what I have seen, which is, let me see how many people I can bring in to testify for me, even if they don't have first-hand information. I've been in hearings that last 2 days, the entire weekend, because anyone and everyone was allowed to come in and testify, which, by the way, kind of destroys confidentiality and privacy, which belong as a right to both parties. So a lot of schools have actually started hiring lawyers because we have Title IX guidance and we have VAWA and we have FERPA, rather than having just some academic, no offense to academics, but decide, very serious matters that they could get sued for later without any kind of legal training. A lot of schools have actually started just hiring people with JDs to be those board chairs, to be those Title IX coordinators. And I think it's just wise from an institutional liability standpoint. It also creates more fairness, especially if you have advisors who are lawyers on both sides trying to hold the school to federal law. Some schools have even moved to having their general counsel room. Am I out of time?
No, that was
Okay, I'm wrapping up, I promise. A lot of schools have moved to have their general counsel room, or even the attorneys general, because there are lawsuits happening, challenging due process, challenging Title IX rights. So they're getting smarter about making sure it's a set-up system with good records, with legal experts, making decisions, and trying to be fair to both parties so that there isn't a question, because that's also unfair to both parties. If there is some error, to go back, to do it again, to go back, to do it again. And I have one client went through 3 hearings and 2 appeals, and there's still a lawsuit pending. She has no idea how that's going to end up, and it's been 2 years. And that's unfair for both parties, right? There should be adjudications that can stand judicial scrutiny. And appeal, I actually think appeal is the best practice. Why on earth would you not want to catch an error? Schools don't have to, federal law doesn't require it, but schools are doing it. But they're doing it in a smart way that limits it, not hearing the entire case, but thinking about, was there a procedural error, and was there new evidence that we just didn't have that we really need to consider. So I think some schools are doing a good job under VAWA. I think it's given them a lot more structure on top of this kind of Title IX guidance. And I'll just say as a last part, we talked a little bit about privacy, and I don't have a long time to go into FERPA, but FERPA violations happen left and right and harm both parties. FERPA is meant to protect the student's education record. An advisor, of course, is allowed to be in the hearing, but a lot of schools have been thoughtful and said, okay, if we're going to have attorneys in the hearing, it's not that they get to do free discovery and, let me pull that document so I can see you later. It's protected. And so there has to be a waiver, there has to be a limitation on redisclosure in compliance with FERPA. Again, temporary access over a cloud, so there can't be copies that are floating out there that are being sent into courts to journalists. And really making sure that redactions are happening. That's actually required. And I would guess that probably 60-70% of schools don't do that. If a document ever was accidentally found, you should know who it was about, because we are protecting the rights of both parties. And prohibiting outside kind of guests from stopping in. I know schools are like, oh, bring your family, have them sit here and hear about your rape accusation and your story of being assaulted and see how that feels. They're becoming a little more serious, a little more focused on privacy, and making sure that survivors have the right to notice that's given under VAWA, but it's also allowed under FERPA. Because there was a question before, does FERPA require or allow schools to find out? FERPA is really weird, and it'll allow things but not require it. So FERPA allows victims to have access but doesn't require it. Clery requires it. FERPA allows a school to tell someone that someone has been found responsible for sexual violence but does not require it, unless there's an educational interest. That's the exception. And last but not least, all these hearings are recorded per Title IX, and so a lot of schools that are doing best practice actually allow advisors and students to hear this if they're mounting an appeal, which of course, best practice, we do that in the real courtroom. So that's the long and the short of VAWA and kind of what I've seen come out of the rulemaking and how I think it's impacted, and I look forward to your questions.
Thank you, Laura. We're running a bit behind time, partly because we started a few minutes late. So let's have just, if there's one urgent question for Laura, let's have that, and then we can continue the conversation during the coffee break.
I have one question. I don't know if it's urgent, but since no one else is asking the urgent question, I mean, just there's something, and this came up in Nance's presentation too, and I wanted to ask you about it, and it's just the use of the term survivor as a synonym for complainant, because it seems like there's a decision being made prior to like an investigation or finding on the guilt of the accused if you're designating a complainant a survivor. I just wanted to ask about what you think.
No, that's a great question. So I'll be clear that survivor is just my term. That is not in the law, and that's not actually what I write.
It's very common practice. I mean,
yeah.
In fact, communiques issued at my university by official committees,
okay.
The term survivor is used as a synonym for complainant.
Gotcha. So complainant is Title IX language, and VAWA actually says victim. It doesn't say alleged victim, it says victim. And that's because we believe survivors, when they come forward, actually the only thing you prove per law is that a crime happened and who committed it. You don't actually prove that someone was harmed. And actually, personally, I think that that's a very damaging way to approach it. When someone comes in and they say, my friend was murdered, you're going to say, are you sure? We're not unsympathetic and skeptic right off the bat. We actually take that complaint and we give them that title and we give them rights. And so, at least under VAWA, you don't have to formally go through any process to be labeled a victim and give the victim's rights. So at least under this law, it's actually perfectly acceptable to call someone a victim regardless of whether they go through a process. And there is an ability to unfound claims, but the standard is very high, and it can only be done by law enforcement, and it can only be done by law enforcement after they've actually done an investigation entirely through and found evidence to support the unfounding. So Violence Against Women Act is very pro survivors, victims, whatever label we want to put on it, and making sure they feel supported and coming forward. So that's the whole purpose of the law. I will say FERPA says alleged victim, and Title IX says complainant. So every law is a little bit different. So that's just the VAWA answer for you.
Okay, thank you, Laura.